Can a criminal complaint alleging animal cruelty that fails to name the source of the information be sufficient? To find out, you have to read People versus Farrell, but it's 7 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Farrell. The citation for this case is 2025 New York Slip Opinion 02100, published by the Court of Appeals on April 10th of 2025. The issue in this case is the sufficiency of an accusatory instrument alleging a violation of Agriculture and Markets Law 353, which is cruelty to animals, when the basis is basically a medical issue and the failure to provide proper sustenance for the dog. To understand and appreciate the context of this case, what's helpful to know, as terms of background, is that under Criminal Procedure Law 100.40, that talks about the sufficiency of accusatory instruments. And importantly, in that section under 100.40, an accusatory instrument to be sufficient has to have non-hearsay allegations, meaning explaining not, I heard from somebody else this. You have to explain the source of the knowledge and how it's direct. That establishes, if true, every element of the offense charged. Okay? Has to be supported by non-hearsay factual allegations. The other thing you have to know is that Agriculture and Markets Law, Section 353, which is called Overdriving, Torturing, and Injuring Animals, is basically a catch-all that says, it's a very long statute, but it says, in short, a person who overdrives, overloads, tortures, or cruelly beats, or unjustifiably injures, or maims, or mutilates, or kills any animal. Importantly, or neglects or refuses to furnish it such sustenance or drink as it may need. That person is guilty of a misdemeanor, a misdemeanor. Okay, so what's the facts of this case? The facts are that in this particular case, it is alleged that the Ulster County Society for the Prevention of Cruelty to Animals sent out an investigator who found a dog in the middle of the road who was very weak, unable to easily stand or walk more than a few paces. They couldn't find the owner, so they brought him in as a stray. They later discovered the dog was named, they called the dog Mogley, and they found that the defendant was the owner. The dog ultimately died because it was so weak and ill. It had a flea infestation. It had a condition called spondylosis, which is an injury that's apparently very common for older dogs to the spine, which causes chronic pain and suffering, allegedly, according to the investigator. So the ASPCA investigator, or the SPCA investigator, filed an accusatory instrument, right? Filed a complaint. They charged the owner, who called his dog not Mogley but Dog, or the dog, and they said certain things in the accusatory instrument. They said the dog had spondylosis, had a mass around its heart, had a flea infestation, and the owner had told the investigator that he had never brought the dog to the vet. So they charged the owner. The owner's the defendant, the owner, the 75-year-old elderly owner of the dog. His lawyer filed a motion to dismiss, saying it's vague. This is insufficient. There's not non-hearsay allegations explaining all the basis of this. And the court dismissed the claim, dismissed the complaint, said it's not sufficient. It's not factually sufficient. It gets appealed. It goes all the way to the Court of Appeals here. And the Court of Appeals ultimately affirms that this was insufficient. Why? They say, they go back to 100.40, and they say 100.40 requires that every element be supported by non-hearsay allegations, and they don't ever explain how they know that there's a mass by the heart, that the dog has spondylosis, and they also say, importantly here, it's insufficient the fact that the owner said he never brought his dog to the vet. That's insufficient to make out this Agriculture and Markets Law violation under 353, and it's also insufficient, the allegation that the dog had a flea infestation. That itself is insufficient as well, because owners can treat them without going to the vet. That's not necessarily a cruelty to animals. So that's the case of People versus Farrell. The allegations are insufficient in general because they're not clearly stated why they're non-hearsay allegations, how the investigator knows these things. And the individual allegations that were made, which is the flea infestation and the failure to bring the dog to the vet, are themselves insufficient specifically. That's the case of People versus Farrell. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.